right. Well, let's get into Carmelo Anthony. You did a great job last week breaking down, the self defense. And of course, we still don't have all the evidence. The police or the DA office have not released any more evidence, but you were able to give good legal analysts to
Analysis of what?
analysis to what we have known so far, and just the whole terminology of self-defense, right? And
Yeah, and by the way, it's looking, the more that comes out, the more it's looking less and less like a proper self defense case, and more like a matter where there was premeditation that was involved to set this up. So, yeah, it's
so,
not looking good, but people are presumed innocent until proven guilty beyond a reasonable doubt.
mhm.
And we have yet to get the indictment process. You want me to jump into what's supposed to happen next? Since
Well,
I can't.
let me just set it up real quick. And I do want to share this here. So Carmelo Anthony, who is 17 years old, he's accused of stabbing another high school student at a track meet last week. He was released Monday today after his bond was significantly lowered. He Anthony was released from Collin County Jail at 4:20 p.m. and put on house arrest with an ankle monitor after an 8-hour long hearing at the county courthouse in McKinney on Monday morning. State District Judge Angela Tucker lowered Anthony's bond from $1 million to 250. Anthony,
250,000.
yes, 250,000. Sorry. And he has been charged with murder since April the 2nd. And
What degree?
hmm?
What degree?
It doesn't say. It just says
Of course, the typical modern news media wouldn't think that that's important, but it is.
yes, it is. So while under house arrest, Tucker said Anthony will only be permitted to leave home with her permission, namely trips to his attorney's office and meetings in court, and will need to be with an adult at all times. He is also not to contact the McCaff family, including on social media. Factors considered in court on Monday included Anthony's age, lack of criminal history, and ties to the community, including several family members, close friends, and a football coach and a manager from one of his part time jobs. He showed up to the hearing. Who
I
showed
always found that the greater the extent of the defendant's youth, the more unreliable they are about showing up. The older they are, the more reliable they're likely to be about returning until the matter is disposed of. So I don't know what that had to do with why the bond was lowered, but that's not my call right now. I'm just making an observation. But as I said before, the bond heretofore set was excessive. 250,000 is more reasonable. But the more I hear about it, worse it looks. So we'll see what happens. And as I have observed on many occasions, what you hear in the press or through the press or gets revealed by the press, particularly these days, is not very reliable compared to what you hear on a witness stand.
Mhm.
But it looks like, one, why is he carrying a knife to a track meet when he's a participant in the meet? Two, why is he under a tent shelter on the wrong team side? Why is he where somebody else is on that team that he has a prior animosity with? Why is he on social media in the preceding week boasting or advertising what he's going to do in retaliation? And then he may get beat up, but you have people saying, well, the disparate size Well, that doesn't matter. It's a young athlete, and he did play football, and he's going to run into linemen if he's playing football who are as big as the deceased, if not bigger. So that doesn't wash when you get to talking about disparate treatment.
Well, there have been more to it with the story, but I want to play this clip of DA Greg Willis. That's the DA's whose case this is whose DA's office is going to be handling this case. So this is the DA talking after the bond hearing.
All right, there's not much I can say. The judge has made the call, and so what's important is what's next. Frisco PD will be finishing up their investigation. They will submit the case to my office. We will review it and ultimately present it to a grand jury. And so that's what's next. That's really much, it's pretty much all I can say right now. We do our speaking in, as far as the facts go in the courtroom. Many of you were in there, so you understand what was said. But this is a terrible tragedy for our entire, not just Frisco, but Collin County community. One family has suffered a permanent loss. It's the most unnatural thing for a parent to lose their child. It's permanent, it's profound, it's certainly premature, and it's the hardest thing that I think a human being can go through is to lose their child. The Anthony family has had a different kind of loss, but a loss nonetheless. But the judge has made her call, and we look forward to continuing the process and looking forward to reviewing all the facts of the case that Frisco PD is coming up with and present it to a grand jury. What we're concerned about as prosecutors is justice, truth, and accountability. And so we will go where the facts lead us. Thank you so much.
Could you speak about the security and the vitriol and just the safety even for the judge and your officer?
Well, this has definitely rocked our entire community. And so it has struck a nerve in the community. And it's hard for everybody to be level-headed at a time like this. So that's where we come in. It's our job to be level-headed, to be fact-based, and to follow the truth wherever it leads. Thank you so much.
And what is your guidance for those that don't know? Thank you.
So I want to add this for a little bit of context here, right? Karmelo Anthony father, he is not on camera, but he was briefly interviewed by the New York Post. And he says, everyone has already made their assumptions about my son, but he's not what they're making him out to be. He's a good kid. He works 2 jobs. He's an A student, has a 3.7 GPA. The elderly Anthony insisted his son didn't instigate the tragic brawl over a seat at the track stadium in Frisco, Texas, where the boys' school had met for a track meet. He was not the aggressor. He was not the one who started it. He is charged. Karmelo is charged with first-degree murder. Anthony said his son's action was a heat of the moment mistake that has brought tragedy to both families. Quote, I feel bad for the other parents and family, and words can't explain how both families have been affected by this tragedy, end quote. So it says the senior, Karmelo, he was a senior at Centennial High School, was allegedly told he was sitting in the wrong seat before he drew a knife and launched his attack, the father of the victim said. Karmelo allegedly stabbed Austin McCaff in the chest as his victim, identical twin brother, watched in horror. And that's when
the problem is what are you doing with the knife at the school? It's got to be a knife long enough to penetrate through the rib structure into the thoracic cavity to do something to the heart lung situation there. if you're going to take somebody out. The other thing is if we're talking about basically just unarmed physical force, how anyone justifies stabbing someone in the chest. So what we're talking about, the father talked about, is passion, and that would, if the jury went for that, brings it down to second degree murder or manslaughter. The state of Texas may call that something else, but essentially that would be what is at common law. Second degree murder is the commission of a homicide in the heat of passion induced by provocation that caused the defendant to act in an irrational fashion. Manslaughter is the commission of a homicide upon passion induced by provocation that would cause an ordinary and reasonable person to act irrationally. And there is the difference, that reasonable person, ordinary person versus the defendant himself with his peculiarities and individual nature. In other words, if you can convince a jury that under the circumstances that exist in this case, that they would likely act in an irrational fashion and commit the homicide, then you've got a good manslaughter chance here. If you show that the defendant, through his particular circumstances, which the jury might not identify with but might recognize, then you've got a second degree murder case. But here, from what I've heard on the facts, assuming there's any validity to them, that's probable cause to charge first degree murder, where the homicide was committed with supposed, well, in a lot of states it would be called premeditation. In other words, you thought about it and you planned it out.
So, but that's the thing. In what regard would it have been planned out? Because they didn't know each other.
Well, then that's contrary to what's going on, because the reports I've been seeing are that they had a prior situation. So that would make
And that's what I'm saying with, see, the police and the DA office have not released any official evidence, right? So that what you just, that was all speculation. Because let me just say this, because what's coming out now is they did not know each other prior to being under the tent. And when he went under the tent, because it was raining, so he went under there for shelter, that's when Austin said, get out of here, basically. Don't sit under this tent. And that's when
if he said that, there may be some basis to it. In other words, that belonged to that team, not the other one. So you don't go to this high school, you need to leave. So if it went from there, fine, but he still got the problem with having the knife.
Mm-hmm.
Now, why would he perceive that he needed protection at a track meet?
I don't know.
There you go.
Okay, so
now see, the other thing is if he alleges self-defense, the state's going to have to prove that he did not act in self-defense in a lot of places. Some states, self-defense becomes an affirmative defense. You have to prove that to the jury and put on proof. You don't necessarily have to take the stand, but you have to raise the issue. And if the state removes it, you get caught up with explain yourself. How do you claim self-defense on this? In other words, the assault thing, putting a person in a state of apprehension that an unpermitted touching is going to occur. In this case, before you're entitled to use deadly force against another human, you have to have a reasonable anticipation that deadly force is going to be used against you. such that you would be in jeopardy of suffering death or serious bodily injury or serious bodily harm or great injury, etc., depending upon how the state defines it.
Anthony has been released from the Collin County Jail after posting bond. A judge reduced his bond this morning from $1 million to $250,000. He's facing a murder charge after police say he stabbed another teenager, Austin Metcalf, while at a track meet at a Frisco high school. Stephen Dial is in McKinney with more. Stephen.
Karmelo Anthony left the Collin County Jail in a suit but had nothing to say to the reporters before he got into that vehicle. The district court judge says that she looked at all the factors in this case, him not having a criminal history, and that led to her making her decision to reduce his bond. 17-year-old Karmelo Anthony was silent after bonding out of the Collin County Jail and being placed on house arrest.
How is this self-defense?
2 days after the family of Austin Metcalf buried their son, they were at the Collin County Courthouse for a bond reduction hearing Monday. Karmelo Anthony is accused of stabbing and killing Metcalf at a Frisco track meet earlier this month. The case has quickly become national news, drawing a lot of attention, resulting in threats and increased security at the courthouse.
Threats and, talk of race war and all kinds of insanity isn't good for, obviously, the Anthony family. It's not good for the Metcalf family.
Cameras were not allowed inside the courtroom, but we did capture the Anthony family arriving. His father, Andrew, testified in the hearing. District Court Judge Angela Tucker said that she's never gotten this volume of calls and had to have this level of security in the courtroom in her 13 years on the bench. Court documents say Anthony stabbed Metcalf during a fight. When an officer arrived, court documents say Anthony told the officer, "I was protecting myself." Collin County District Attorney Greg Willis spoke after the hearing.
The judge has made the call, and so what's important is what's next. And it's our job to be level-headed, to be fact-based, and to follow the truth wherever it leads.
Anthony's father testified he's taking a leave from work because of the incident, and his wife is a stay-at-home mother with 3 other children. During the hearing, the prosecution brought up the fact that more than $400,000 have been raised for the Anthony family, saying a reduction is not needed because they have the funds. A big question in this case will be, why did Anthony bring a weapon to a high school stadium? It's a question that was asked of his attorney.
That's an understandable question, but it's not something that, frankly, we're prepared to even go into.
Now, in the opening statement to the media from that interview that you just heard, he led with talking about self-defense. Again, the court documents mention self-defense. We'll have to wait and see how that defense will be made in court when things pan out. Now, according to the judge, the terms of the bond are house arrest and ankle monitor. She told him to stay off social media, and he has to personally call her bailiff every Friday morning, not his parents, but him. And there's a list of other things that is set. And if he violates that, he'll return to the Collin County Jail.
You should have put an ankle bracelet on him.
They did.
Okay. The thing here is this. He's the one that shot his mouth off and said, "I defended myself." But you see, that's the lay idea of, I had a right to do that. No, you don't. You have a right to fist fights. I mean, if all you're going to take is a physical beating that is not going to be life-threatening, even if you're going to take that beating, you don't have any justification for using deadly force to resist it. It's just you got your butt beat, plain and simple. But if all you're facing is getting your behind whipped, you can't kill somebody under those circumstances, because it must be something that causes a reasonable belief that you are in danger of suffering death or serious bodily injury, which is not a split lip, black eye, or bruises. It has to be a life-threatening injury. Mm-hmm. And that's not likely to happen between 17-year-olds in an unarmed fist fight. not without some particular circumstances. Actually, it looks worse now that you tell me they were not acquainted with each other, because he, unlike the previous tales, would have no reason to think this particular individual was going to do him harm. And all that's going on is, by the way, evicting somebody in a trespass situation. And believe me, under the law, when somebody's trespassing, you can lay hands on them to eject them.
Well, he wasn't trespassing.
Well, yes, he was in this tent. I saw the video for the tent, and
Yeah, but you can't.
It's on the other team.
But no. When I say he wasn't trespassing, it's not against the law, or it's not against any type of policy that you can't go under another school tent.
Well,
he wasn't trespassing because there's no policy or prohibiting you from doing that, one, and then two, it was raining, so you dash under for shelter. So that's
what you get wet otherwise. But you see, it is trespassing if somebody tells you you do not have license nor invitation to be up under here. This is reserved for people in a certain category. You have to leave. You've been advised that you no longer have an invitation or entitlement to be there. You have to leave. If you don't, you're in a condition of trespass.
Oh, if that's the case, Austin McCaff did not have a right to tell him that, because he was not the authority. He was not a school official. He didn't pay for that tent to be there. He wasn't a sponsor. So
he doesn't have to be.
He didn't have the authority to do that.
He could have had it designated. When I went to school,
he was not.
When I went to school, they had hallway monitors, and hallway monitors were students. And we could say, you need to show a pass if you're out here. Otherwise, you need.
He wasn't a monitor.
He doesn't know that. The actor who is charged says he told me I had to leave. He has to show that, or have from the proof.
Rival.
Listen to me. It is, because when somebody tells you you should not be in here, you have no business in here, you'll have to leave. If he's going to rely on the whole line of logic that he's got, he's going to have to lay it out. I knew he had no authority. How does he know that? He can't show that.
He was a student.
Have to get up. He can't show it. And the other person is simply claiming it on behalf of the school. In other words, if you're a student and a trespasser walks through the front door of the public school, but they're not a student, but they're at student age, the students, anybody else can inquire and say, why are you in here?
Okay, they can inquire, but you cannot wait. But you cannot direct or put hands.
Yes, you can.
No, you cannot.
All of this stuff comes in, but no, you don't. That's just something that somebody has on as a superfluous requirement. It's dangerous, so you have security. That does not deprive anybody of the authority to demand the person explain why they are there if they themselves have a legal status or a permitted status. In other words, if you're in some place and you have the license or the invitation to be there, you may inquire of a stranger what they are doing there. And you see, one thing that people made a big mistake on, and they recently, big mistakes, is that they think that, so what if I'm trespassing? He doesn't have the authority to move me. He has to call the police. A person who is announcing trespass, if he does so, and he is not out of line doing it, and somebody violates the trespass, he may do it at his own peril, but he can lay hands on somebody and eject them. And the point is,
he can.
He can. In other words, you can toss the person out through the door, out through the portal, out into the streets, lay hands on them and eject them, shove them, grab them, yank them, remove them. You see, if somebody is trespassing, that is not.
But he was not trespassing.
He is. He'd had,
How do you know he's
in other words,
trespassing?
let's take your line. We have all of these other things because of security measures and because of the fact that there may be a fight or violence that occurs. That's on the upswing. So you have a student in the wrong place. He's been advised this is some area that is reserved for school A. You belong to school B. When I went to high school, we couldn't have night football games in the Southern League in Los Angeles because there were so many fights and so much disorder. So we had a concern with public safety. You did not have members of the opposite team going over to the other side. And this is 60 years ago, more than 60 years ago. So it ain't nothing new. And it just didn't happen because you wanted to keep down the violence. So you have one student coming over to the other side. I want to get in out of the rain. Well, maybe the other kid was wrong. Maybe he laid hands upon him, but no how, no way does he exercising this apparent authority, this laying upon of hands, or even battering him by doing an unpermitted touching. No how, no way does that justify somebody using deadly force on him. The law is kind of a slam dunk. It's been the law for the last 1,000 years. So, or developing to where it is now for the last 1,000 years, and for the last 100 or so, it's been consistent. If somebody lays hands on you, you may resist. If you use deadly force against them and all they did was to lay hands on you, you better good and damn well be able to prove sufficient disparate force that you are likely to be killed or suffer life-threatening injury. Now, the problem is this kid ran his mouth off and said, I was defending myself. So the defense is going to have to show, maybe, or the prosecution is going to have to show that it did not have a situation where this kid was in danger of suffering death or life-threatening injury. All right? And he's not going to be able to do that. He stabbed the boy in the chest. He shot his mouth off before they had a chance to question him. It's called a spontaneous utterance, which is admissible. And he said, I was defending myself. At that point, he sets the stage. They, the prosecution being they, can use that statement in evidence against the defendant. Now the defendant has to claim self-defense, and the question becomes, what about the situation caused him to have a reasonable belief that he was going to suffer death or serious bodily injury, which translated comes into life-threatening injuries? So what about that situation caused him to have that development? And since he did not have that, he can't show that unless he's going to show some particular circumstances, and it's not going to wash, because if he tries to introduce through people his weight without him testifying, it's going to be okay. So what? Are you or are you not aware that the defendant played football? Okay. You can call in a coach, several coaches. Do you have any 130, 135, 140-pound football players? Yes, I do. What do the linemen on your team weigh? So and so and so and so. What is the line average for the front four, front five in a high school situation? I went to a place, Southern League. They averaged out 240, 250.
That is you inserted your own personal opinion.
Of course, that's what you do.
You gave an example when you were in high school that your high school had security or violence issue with another high school. That's your situation. You cannot use that in this, because there was no pretense of any type of violence or tension between the two schools. There was open tents on bleachers. So there was no such thing as trespassing in none of those policies. If you hopped under somebody's tent real quick because it was raining, that's not trespassing. It is open space. Nobody owns that stadium, not the school of Austin McClav or Karmelo Anthony. So trespassing is not a goddamn issue. That's not even relevant because he was not trespassing. I get I get your analogy. You walked in another school's place, but that was you walked under another school tent, and that wasn't your school. And the two guys or the one guy said, "Get from over here because this is not your team. This is not your school, and we don't want you here." And that's when the incident apparently ensued. But you can't throw trespassing in there because it wasn't trespassing.
Yes, it
I
was.
mean,
But
you
check,
there's no trespassing because that was not their property. That was not their property. Trespassing is when you trespassing against someone's property. That was not Austin McCaff's school's property. So it was just a tent. That was a majority of people that was running under that school was sitting under that tent. He only went there not to just chill out, just for shelter for a quick minute and then leave, but it was an altercation that took place. You're now throwing in trespassing. Maybe the DA would try to throw that in.
okay, now let me defeat that to show you what you're going astray from. Let's supposing that this came to the team bench. The teams don't own those benches unless the game was being played at their particular high school, their venue. That bench would then be assigned to the school. But even if it was in a public stadium, they are assigned that bench. So let's supposing the football team or the track team is sitting out on the bench with the coach standing in front of them, the water boys at each end, the trainers with the towels and stuff in case there's an emergency, and four guys from the opposing team walk across the field and decide to sit down. Do you mean they're supposed to have to call the police to say, you can't be here interfering with our team, where you hear the team instructions, where you're sitting this near to the action? Leave, go back on the other side of the field. See, they can say that. And when they tell somebody that, that sets up a condition of trespass because that other athlete, that student from the other school, has no business trying to intrude themselves sitting in the midst of the other team. Now, see, that's what comes in. And if you have a smart DA, they'll bring that up. What is likely to happen is the DA is going to say, at the worst, what this dead boy did was announce that the defendant was trespassing and ask him to leave.
Okay.
And at that point, I don't care whether he laid hands on him or not, there was no justification, according to the prosecution side, to deal with moving it to deadly force and stabbing this guy in the center or in the chest area, the thorax, with a knife. Now, he said, he said, I was defending myself from what? A butt whipping. Well, you can't kill somebody because you got your butt beat.
It's a high school track meet. It start pouring down raining and people are just running under for shelter. You know how many times I've been to high school events where it rains and then you all just huddle under whatever shelter. So it's people from different teams huddling together until the rain is dissolved and then you go back to your own team place.
This is not a large tent structure. What is being depicted is a very small awning shelter that probably could have gotten a table under it and 6 chairs. Now, that's how small it is. So here you have somebody from the opposite team going to take up that much space from the shelter. Okay, fine. So nobody is entitled to tell him to leave. And if they tell him to leave, they have to suffer his presence. Let me tell you how it's going to develop.
Okay.
What's going to develop is some hot-headed kid that didn't have the personal courage and bravery to go have a fight, had a knife, and he was on the wrong side. And he got angry because somebody asked him to step in the rain because this awning was not set up for the opposing team. If they wanted someplace to shelter, their team could have set it up. So when he's asked to leave, there's a hands laid on. Even if the other kid who's dead was wrong for doing it, even if he committed an assault or an assault and battery, The problem is that the defendant ran his mouth off when he didn't have to, with a Fifth Amendment framework that he could have stuck himself into and prospered. He said, I was defending myself. That will be used in evidence. Defending yourself against what? Well, I was there and they told me to leave. So they're telling you you're trespassing on their territory. Okay, fine. So what happens? Does he want to take the stand and let this come out? He'll take the stand and testify if he wants to. He has no prior record, so there are no prior bad acts they can bring up. So the question becomes, all right, you want to testify. Explain why you stabbed him in the chest with a knife instead of hitting him with your fist.
Mm-hmm.
So you can't explain that because you admitted that you used deadly force. I was protecting myself.
So let me add
You
this.
can't use deadly
Let me ask
force
you a question.
against in those circumstances. By the way, the judge is going to recite the law to the jury if that comes up and define what trespassing is.